So if the determination is made that the juvenile is not going to be released, then law enforcement, as set out by our laws, has got to take that child to a juvenile detention facility. And there will be a determination at a later point, usually after some sort of evaluation and reports to a magistrate or a judge, an associate judge, something of that matter, about where and how that juvenile is going to be released, what conditions are going to be placed on that juvenile, and things of that nature. So if a determination has been made that the child is not going to be released, the parent or guardian of that child, or parents or guardians of that child, they're going to be given notice that there's going to be, within 24 to 48 hours, and no more than 48 hours from the initial detention, there's going to be a hearing regarding release. And that notice can just be over the telephone, and it often is, because of the volume of cases that law enforcement has to deal with, and because the hearing is so quick after the initial arrest, because they're juveniles, because they're under the age of 18. So that determination is going to be made, and then notice of that hearing is going to occur, and then that detention hearing is, like I said, going to occur within a very, very short window. So regarding interrogations and confessions, juvenile offenders have the same rights of the right to silence, the constitutional right to silence, both under the state and federal constitutions, and they can invoke those rights. There's also a prohibition of use, presumption that juvenile statements made in custodial interrogation are generally not favored and may not come in no matter whether the Miranda warnings were given or not. And if you don't know what Miranda warnings are, it's being notified of your right to silence, that you may waive that right, and if you do, anything you say can and will be used against you in court. So these are factors to consider. Again, there's a general prohibition about the reliability of a juvenile's statements made in custody. The other thing that juveniles have is they have a right to counsel, and they can have an attorney appointed for them, especially at these early stages in the case, and they don't have the right to act as their own counsel absolutely like a regular citizen does. A citizen can go forward pro se and they can act as their own attorney. The problem with that is they're held to the same standard that an attorney is, including knowledge about the rules of evidence, the procedures in the courtroom, the Texas Penal Code, the Texas Rules of Evidence, the Texas Family Code, and all the other factors that control what goes on inside the juvenile justice system, the Code of Criminal Procedure, etc. So going pro se, frowned upon, especially in the juvenile justice system, but it can be done.